Welcome to The Docket. I'm your host, Corey Snow. In this episode, we're going to hear the legal filing by Special Counsel Jack Smith, in which he reveals that Trump Employee 4, an unindicted individual, was about to be charged with perjury for lying to the grand jury. That individual recanted his previous testimony and is now testifying to criminal activity on the part of Trump and his co-defendants, Joaquin Nauta and Carlos de Oliveira. This filing is primarily laying out the reasons why the attorney representing Nauta has a conflict of interest because he also represented Trump Employee 4, but the details revealed are rather significant. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. United States District Court, Southern District of Florida, West Palm Beach Division. Case number 23-80101-CR-Cannon. United States of America Plaintiff v. Donald J. Trump, Joaquin Nauta, and Carlos de Oliveira, defendants. Reply in further support of government's motion for Garcia hearing. The government files this reply in further support of its motion for a Garcia hearing and to address, quote, the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or to seek post-indictment hearings on matters pertinent to the instant indicted matter in this district, end quote. ECF number 100 at 2. As set forth below, following the indictment in this case, the government continued to investigate false statements by two witnesses in the District of Columbia, and the hearing before the chief judge in the District of Columbia appropriately stemmed from that investigation. The government promptly notified this court of its request for that hearing, and Mr. Woodward participated in the hearing without objection. The government addresses these matters and the need for a Garcia hearing below. Background. In April 2022, a grand jury in the District of Columbia began investigating potential mishandling of classified documents by Donald J. Trump. The investigation derived from a referral to the Department of Justice by the National Archives and Records Administration. The FBI opened an investigation on March 30, 2022, and the grand jury's investigation commenced the following month. Among other things, the investigations gathered evidence that Trump and Joaquin Nauta endeavored to obstruct the investigation by the grand jury sitting in the District of Columbia. During these investigations, the government gathered evidence that Trump employee Carlos de Oliveira tried to enlist the Director of Information Technology for Mar-a-Lago, identified in the superseding indictment as Trump Employee 4, to delete Mar-a-Lago security footage after the grand jury in the District of Columbia had issued a subpoena for the footage. As set forth in the government's motion for a Garcia hearing, before Trump Employee 4's appearance before the grand jury in the District of Columbia, the government informed Mr. Woodward that his concurrent representation of Trump Employee 4 and Nauta raised a potential conflict of interest, and Mr. Woodward responded that he did not have a reason to believe that his concurrent representation of Trump Employee 4 and Nauta raised a conflict of interest. When Trump Employee 4 testified before the grand jury in the District of Columbia in March 2023, he repeatedly denied or claimed not to recall any contacts or conversations about the security footage at Mar-a-Lago. In testimony before the grand jury, de Oliveira likewise denied any contact with Trump Employee 4 regarding security footage. The government's evidence indicated that the testimony by Trump Employee 4 and de Oliveira was false. On June 8, 2023, a grand jury in this district returned a 38-count indictment that charged Trump with unlawful retention of national defense information and charged Trump and Nauta with obstruction of justice offenses. The indictment did not name de Oliveira as a defendant or contain charges regarding the efforts to delete security footage. The government thereafter continued to investigate the false statements by Trump Employee 4 and de Oliveira in the District of Columbia. On June 29 and July 11, 2023, the grand jury issued 2 subpoenas for footage from 3 security cameras at Mar-a-Lago that related directly to de Oliveira's solicitation of Trump employee 4 to delete security footage, as well as the false denials of the same by both witnesses. In addition, on June 20, 2023, the government advised Trump employee 4, through Mr. Woodward, that he was the target of a grand jury investigation in the District of Columbia into whether he committed perjury there in violation of 18 U.S.C. Section 1623. Trump employee 4's criminal exposure identified in the target letter was entirely due to his false, sworn denial before the grand jury in the District of Columbia that he had information about obstructive acts that would implicate Nauta and others. The target letter to Trump employee 4 crystallized a conflict of interest arising from Mr. Woodward's concurrent representation of Trump employee 4 and Nauta. Advising Trump employee 4 to correct his sworn testimony would result in testimony incriminating Mr. Woodward's other client, Nauta, but permitting Trump employee 4's false testimony to stand uncorrected would leave Trump employee 4 exposed to criminal charges for perjury. Moreover, an attorney for Trump had put Trump employee 4 in contact with Mr. Woodward, and his fees were being paid by Trump's Political Action Committee, PAC. See, in Regarding Grand Jury Investigation, explaining that potential conflicts can be, quote, further heightened by the financial dynamics of joint representation, end quote, where, for example, a client, quote, did not independently select the, end quote, attorney, but instead had the attorney, quote, pre-selected for them by the attorney to the person who is the central focus of the grand jury proceedings, end quote. On June 27, 2023, consistent with its responsibility to promptly notify courts of potential conflicts, and given the prospective charges for Trump employee 4 faced in the District of Columbia, the government filed a motion for a conflicts hearing with the Chief Judge of the United States District Court for District of Columbia, Boasberg, C.J., who presides over grand jury matters in that district. The government notified this court on the same day by sealed notice of the filing in the District of Columbia. Mr. Woodward raised no objection to proceeding in the District of Columbia regarding Trump employee 4. In fact, he responded that he, quote, welcomed the court's inquiry into his representation of, end quote, Trump employee 4, but asserted that he had no, quote, information to support the government's claim that Trump employee 4 has provided false testimony to the grand jury, end quote, and that, quote, even if Trump employee 4 did provide conflicting information to the grand jury that could expose him to criminal charges, he has other recourse besides reaching a plea bargain with the government. Namely, he can go to trial with the presumption of innocence and fight the charges against him, end quote. According to Mr. Woodward, if Trump employee 4, quote, wishes to become a cooperating government witness, he has already been advised that he may do so at any time, end quote. Chief Judge Boasberg made available independent counsel, the first assistant in the Federal Public Defender's Office for the District of Columbia, to provide advice to Trump employee 4 regarding potential conflicts. On July 5, 2023, Trump employee 4 informed Chief Judge Boasberg that he no longer wished to be represented by Mr. Woodward and that, going forward, he wished to be represented by the first assistant federal defender. Immediately after receiving new counsel, Trump employee 4 retracted his prior false testimony and provided information that implicated Nauta, de Oliveira, and Trump in efforts to delete security camera footage, as set forth in the superseding indictment. The government anticipates calling Trump employee 4 as a trial witness and expects that he will testify to conduct alleged in the superseding indictment regarding efforts to delete security footage. Trump employee 4 will very likely face cross-examination about his prior inconsistent statements in his grand jury testimony, which occurred while Mr. Woodward represented him, and which he disavowed immediately after obtaining new counsel. Argument 1. Continuing to investigate Trump employee 4's perjury before the grand jury in the District of Columbia was entirely proper. It is well established that after defendants have been charged in an indictment, the government may continue to use a grand jury, quote, to investigate other persons who were not charged in the initial indictment, end quote, or to, quote, explore the possibility of filing additional charges against the same defendants, end quote. Even if the grand jury does not ultimately return new charges, quote, if in the course of such legitimate investigative efforts the prosecution obtains evidence that is relevant to the pending case, it can use that evidence at trial, end quote. To be sure, quote, the grand jury cannot be used solely or even primarily to gather evidence against an indicted defendant, end quote. But, quote, the law presumes, absent a strong showing to the contrary, that a grand jury acts within the legitimate scope of its authority, end quote, and the defendant has the burden of showing that the government's use of the grand jury was improper. Following the indictment in this district, it was appropriate to use the grand jury in the District of Columbia to investigate false statements by Trump employee 4 and de Oliveira. Neither individual was named in the indictment against Nauta and Trump, and venue for changes based upon their false statements in the District of Columbia would lie only in that district. It therefore necessarily follows that the grand jury was not used, quote, for the primary purpose of strengthening its case on a pending indictment or as a substitute for discovery, end quote, even if that, quote, may be an incidental benefit, end quote. The decision in Beasley is instructive. After the indictment, the government gave a witness who had previously testified before the grand jury the opportunity to recant his false testimony, and the witness recanted and testified against the defendant at trial. The Court of Appeals found that it was, quote, not improper and indeed totally consistent with the duty of federal prosecutors to advise a witness that there exists a serious doubt or question about that witness's testimony, end quote. The court determined that, quote, the primary purpose of calling the witness before the grand jury after the indictment was not one of gathering evidence against, end quote, the defendant, but instead, quote, was to present to the grand jury the question of false statements under 18 U.S.C. Section 1623 or provide an opportunity to recant, end quote. A claim of improper use of the grand jury here is even further afield than in Beasley. Whereas the recanted testimony in Beasley was relevant only to the charges pending in the indictment, as described above, Trump employee 4's corrected testimony is probative of, quote, crimes not covered in the indictment, end quote. Not only was it appropriate to use the grand jury to investigate false statements by Trump employee 4 and de Oliveira, it was appropriate to use the grand jury in the District of Columbia, where the statements were made and where venue for any false statement charges would be proper. See United States v. John, 11th Circuit, 2012, unpublished, concluding that venue for a violation of 18 U.S.C. Section 1001 is, quote, proper only in the district or districts where the defendant made the false statement, end quote. United States v. Paxson, D.C. Circuit, 1988, upholding conviction for perjurious grand jury testimony in the District of Columbia material to antitrust charges subsequently brought in the Northern District of Georgia. And it was necessary to bring to the attention of the chief judge in that district the potential conflict that arose from Mr. Woodward's representation of Trump employee 4 in those proceedings. As, quote, an incident of its supervisory power, a court has jurisdiction, end quote, to consider potential conflicts of interest that, quote, relate to a grand jury proceeding within that court's control, end quote. And when the government discerns such a potential conflict of interest, it, quote, is not only authorized, but is in fact obligated to bring the problem to that court's attention, end quote. Nauta is therefore incorrect when he claims that the government was, quote, attempting to diminish the court's authority over the proceedings in this case and to undermine attorney-client relationships, end quote. When a conflict arose in the context of Trump Employee 4's status as a putative defendant in the District of Columbia, the government raised the conflict's issue there. Now that a conflict arises from potential cross-examination of Trump Employee 4 in the case against Nauta in this district, the government has raised the conflict's issue here. Nauta makes no showing of improper use of the grand jury, let alone the strong showing that is required to rebut the presumption of regularity in grand jury proceedings. The circumstances here foreclose a contention that the grand jury was used merely as a discovery tool to support the charges in the pending indictment, and Nauta's reliance on cases that apply this established rule, including National Window Glass Workers, is unavailing. Footnote 1. Nauta also errs to the extent he suggests that the government's earlier use of the grand jury in the District of Columbia was improper, simply because the government ultimately brought charges in the Southern District of Florida. Courts have long recognized that, quote, the scope of the grand jury's inquiries is not to be limited narrowly by questions of propriety or forecasts of the probable result of the investigation, or by doubts whether any particular individual will be found properly subject to an accusation of crime. End quote. Because, quote, the identity of the offender and the precise nature of the offense, if there be one, normally are developed at the conclusion of the grand jury's labors, not at the beginning. End quote. Blair v. United States, 1919. Quote, hindsight is not the proper perspective for discerning the limits of a grand jury's investigative power. End quote. For the grand jury, quote, must pursue its leads before it can know its final decisions, end quote. Paxson. When the government started the grand jury investigation in the District of Columbia, it could not know the full scope of the evidence that would be gathered, but from the outset, the investigation encompassed conduct that spanned the District of Columbia and the Southern District of Florida, and the investigation uncovered evidence of federal offenses in both districts. The government's decision to ultimately bring charges in the Southern District of Florida and not in the District of Columbia does not call into question either grand jury's investigation. The government notes that the grand jury in the District of Columbia completed its term on August 17, 2023. 2. A Garcia hearing is required, where, as here, an attorney, quote, has previously represented a person who will be called as a witness against a current client at a criminal trial, end quote, in a substantially related manner, that attorney has an actual conflict of interest. United States v. Ross, 1994. A scenario that, quote, presents defense counsel with the impossible dilemma of cross-examining one former client to benefit another current client is wrought with conflicts, end quote. United States v. Braun, 2019. Accord United States v. Schneider, 2021. When the government intends to call defense counsel's prior client as a witness against the defendant and, quote, vigorous cross-examination, end quote, of that witness is required, defense counsel's prior representation of the witness renders him, quote, unable ethically to provide that cross-examination, end quote. Wheat v. United States, 1988. Thus, Mr. Woodward's successive representation of Nauta and Trump Employee 4 squarely implicates his ethical obligations. Even if Mr. Woodward was, quote, unaware at the time he represented Trump Employee 4 that his client might give testimony that would incriminate Nauta, he is certainly aware now. This court should decline Mr. Woodward's invitation to hold the entire Garcia hearing ex parte. While it may be appropriate to conduct portions of the hearing ex parte, for example, if the court were to find it necessary to inquire into attorney-client communications between Mr. Woodward and Nauta, the need for judicial inquiry into conflicts of interest derives from the interests of the court and the government in ensuring that the proceeding is conducted according to the applicable legal and professional standards. 3. It would be error to suppress Trump Employee 4's testimony. Nauta contends that if the court finds a conflict, it should preclude Trump Employee 4 from testifying at trial rather than employ more routine remedies. That proposed remedy is contrary to precedent and, except for the district court ruling reversed in United States v. Messino, 1999, would appear to be unprecedented. Courts have rejected exclusion of evidence as a remedy to avoid a conflict of interest, concluding that evidence that is, quote, relevant to the government's case, end quote, should not, quote, be excluded to accommodate a defendant's choice of counsel, end quote. United States v. Urbana, 1991. C. Messino. United States v. Lech, 1995. Exclusion of probative testimony, quote, is an extreme sanction and would only harm the interests of justice, end quote. A, quote, defendant's choice of counsel should not, quote, take precedence over the government's discretion in deciding what charges to prosecute and how to present its case, end quote. United States v. Pungator, 1990. Messino, on which Nauta principally relies, directly undermines his argument. There, the district court excluded testimony from defense counsel's former client to avoid a serious conflict of interest, emphasizing that the conflict came to light on the eve of trial and would have required disqualification of the attorney who had represented the defendant, quote, in several related proceedings over the space of 8 years, end quote, making it, quote, a practical impossibility to appoint new counsel who has comparable experience and knowledge of the case, end quote. The Seventh Circuit reversed, concluding that although counsel's disqualification would have, quote, regrettable consequences, end quote, those consequences could not outweigh, quote, the probative value, end quote, of the witness's testimony. The testimony by Trump Employee 4 is similarly highly probative and unavailable from other sources, and the ample pretrial notice provided here presents the opportunity to ameliorate any potential negative consequences resulting from the conflict. For example, the court may consider whether Mr. Woodward has taken adequate precautions to ensure that co-counsel is fully walled off from whatever client confidences Mr. Woodward learned during his representation of Trump Employee 4. And whether Nauta would agree to cross-examination of Trump Employee 4 by walled-off co-counsel. To be sure, the Messino court, quote, declined to create a per se rule against excluding evidence to remedy a conflict of interest, end quote. But Nauta has not identified any case, and the government is unaware of one, in which a court has excluded evidence to avoid a conflict on facts remotely similar to this case, where the government put Mr. Woodward on notice long ago about potential conflicts, and he is now seeking to affirmatively use those conflicts to gain a tactical advantage at trial by excluding highly incriminating evidence to the benefit of not only his own client but also a co-defendant, Trump, whose PAC is paying his legal fees. The court should not countenance this maneuver. Conclusion. The grand jury proceedings in the District of Columbia were entirely proper. The court should hold a Garcia hearing with Mr. Woodward's clients present and independent counsel available to provide them with advice should they so desire it. Respectfully submitted, Jack Smith, Special Counsel, New York Bar Number 2678084. By, signed, David V. Harbach II, Assistant Special Counsel, Special Bar ID Number A55030068, 950 Pennsylvania Avenue Northwest, Washington, D.C. 20530. Julie A. Edelstein, Senior Assistant Special Counsel, Special Bar ID Number A5502949. J. I. Bratt, Counselor to the Special Counsel, Special Bar ID Number A5502946. Michael E. Thakur, Assistant Special Counsel, Florida Bar Number 1011456. August 22nd, 2023. This concludes this episode of The Docket. I hope you enjoyed this audio version of Special Counsel Smith's response. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.